Hey there, and welcome back to the Men's Divorce Podcast Live. I'm Scott Trout, Managing Partner and CEO of Cordell and Cordell. And today we want to talk a little bit about debt. What do you do with debt? What happens with it? There's been all kinds of articles about dealing with debt and divorce, before divorce, during divorce, after divorce, and how to deal with that. And so we want to answer your questions. So ask those and submit those in the Q&A section in your Zoom link or however you join today. If you're on YouTube, go ahead and submit those questions. We'll get those answered by our panel of Cordell and Cordell attorneys. And speaking of which, I want to introduce our panel today. Christine Dolan, we're in Colorado. Welcome, Christine.
Thank you. Hi, Scott.
Hey there. And Christopher Kennedy, also another guest that we've had before from Arizona. Welcome back, Christopher.
Thanks, Scott.
So don't forget to go ahead and put your questions in the Q&A section so we can get to those. We have some questions already. We're going to talk a little bit generally about debt itself to make sure that we can cover those. But let's get to a first message and we'll be right back after this brief message.
Holidays are hard for anyone going through a divorce, but I can tell you as a divorce lawyer serving men that for dads, holidays are especially hard, particularly for those grappling with a divorce that they didn't choose. Some of you have been there. But for kids too, those who are entangled in divorce, holidays are often less joyous than they should be. So I ask you to keep these dads and their kids in your thoughts this holiday season. A little encouragement this time of year can go a long way.
All right, welcome back. Let's talk a little bit about debt and debt in and of itself. We were talking off camera about debt and how it's dealt with, and it really varies state to state. Particularly, let's talk to Christopher because in Arizona, Christopher, generally, we use the words a lot, community property, and there are a few states in the country that deal with community property. We'll talk about what that means before we get into the details of how debt is divided.
Sure. Thanks, Scott. So yes, Arizona is what's considered a community property state, along with, I think, approximately 9 or 8 other states here in the U.S. What that refers to is a presumption by the law that whatever property is acquired during a marriage is part of the marital community and therefore is equally part of both partners, regardless of whose name is actually on the title or if you're talking about real property, a deed.
Yep. So I think one of the issues if we talk about debt, in this article I read earlier, talked a lot about just student loan debt. And that is a beast in and of itself. I think it brings into play different challenges from a lawyer's perspective. But, I was talking to a client and we were dealing with debt that's incurred during the separation after we filed divorce. And that's an issue. And he was asking, well, she's run up this bill. She spent $4,000 on a security system. She spent $9,000 on a crystal that she uses with her fortune teller. She's spent, $12,000 doing this type of other landscaping on a rental property that she doesn't need to do it. And the question really becomes, what do you do with debt and how is it divided? So, Christine, I want to talk to you about you're in Colorado, but also licensed in Jersey. Let's talk about really what is considered debt. Is debt during the divorce, after separation, after the filing, is that something that the courts in Colorado would specifically consider dividing as marital debt?
So if you're talking about somebody that is deliberately, increasing the debt line just out of pure vindication, or maybe they're doing it out of spite, that's an argument for the attorneys to make that it should be the separate debt of the person who incurred it. Because in Colorado, unlike Arizona, Colorado is an equitable distribution state. So at the end of the day, the theory is the distribution of the assets and the liabilities has to be fair and equitable to both parties. So of course, going to factor in, let's look at the marital lifestyle. What was the marital lifestyle predicated on? And so we have to do these financial disclosure statements. I'm sure in your jurisdiction, Christopher, you do the same. So part of what the financial disclosure statement's trying to do is help us get a snapshot of what the lifestyle was like. And if it wasn't indicative during that lifestyle to spend $6,000 or $8,000 or $9,000 on a crystal, but now we're deliberately incurring that expense, we're going to make the argument it's not fair and equitable for the other spouse to have to take responsibility or some small percentage of that. It should be fallen on the person who incurred the debt.
Yeah.
But it's a very fact-sensitive analysis, Scott, because it all comes into play in terms of, was the debt premarital? How was the debt incurred? And, a lot of times people go crazy with credit card spending. The analysis there becomes whether or not there was any derivative benefit to the family as a whole, as opposed to somebody going to Victoria's Secrets and spending $10,000 just on lingerie that they're only going to benefit from. Yeah. So really, it's so fact sensitive.
It is. It brings into play even misconduct, because we can talk about financial waste occurring. That's one of the issues.
For sure.
Should be a penalty associated with that kind of spending. So, Christopher, we talked about community. Does facts really matter when it comes to the division of marital debt in a community property state?
It does, Scott. Actually, not only facts, but timing too. So you were mentioning before, as far as, does it matter if it was during the marriage? Does it matter after filing? Here in Arizona, it matters a lot after service, not necessarily filing. Like I said earlier, community, anything acquired during the marriage is considered to be community. However, after the date of service, any of those debts are considered to be sole and separate. So the court will take into account when that debt was incurred. Also, as far as waste goes, the court will look very closely at the time period running up to the filing and service of the petition for divorce. If those charges, if those expenses were made in anticipation of divorce, then the party that made those may be solely responsible for them.
So prior to the filing of the separation or the divorce in Arizona, they would just be split down the middle if they were incurred during the marriage?
Typically, yes, with exceptions. You can always, the standard answer from a lawyer is always, it depends.
Right.
But
right.
Yes, typically, yes, it's considered community and would be split equitably,
Yeah.
Which more often than not is 50-50.
Which is interesting, because here in Missouri, obviously, and while I'm talking about this, don't forget to submit your questions in the Q&A section. I know we have a few already. We'll get to those here shortly. In Missouri, it's very fact specific, and it is a court of equity, which means it can do what it believes to be the right thing based upon the facts and circumstances of the case. So, and again, we would use the word "it depends." Typically, the court is mandated to divide all property and debt that was incurred, whether it's marital and setting aside separate property and separate debt, which calls into question, Christine. We talk a lot about student debt or student loans are a hot topic today, even when, we have the president forgiving some loans. We've been talking about student loan debt probably for about 18 months on a national scale. And that's really a big question, because it's unlikely that you have a student who graduates, whether it be from undergrad or graduate school, then gets married and then gets divorced. It's unlikely for a family to have some student loan debt. So what do you do with student loan debt, and how is that treated by the courts, in Colorado or Jersey where you're licensed?
So in Colorado, we're going to take a look at the timeline, and we're going to try and determine when was that debt incurred. So if the student loan debt was incurred by a spouse prior to the marriage, it is 100% that person's responsibility. The caveat, though, however, is you could put a twist on that scenario, because if somebody brings a debt into a marriage, but then they refinance the loan, and now we're using marital funds to pay down the student loan debt, well, then that's a different story. Now it kind of it takes on a different form. Now it could be marital debt. In terms of student loan debt incurred during the marriage, it really depends on the timing of how soon thereafter do the parties file for divorce. So in other words, if we have a spouse who goes for an MBA and she gets a job, and 6 months after she gets a job, she files for divorce, she's going to be saddled with that student loan debt, because there really was no established derivative benefit to both parties during the marriage from that degree. But if you take that same fact pattern and she doesn't file until 15 years later, then it is going to be a marital debt. Now, it may not necessarily be a 50-50 split of the debt because we still have to do an analysis to try and determine what was the overall generic benefit to the family. Did it increase their standard of living? If there was a significant derivative benefit, then the argument can be made it's a 50-50 split. It does impact maintenance, interestingly enough, which is off topic, but in terms of allocation of the debt, again, like Christopher said, it depends. It's so fact specific.
Yeah, I think what to me is the complication for student loan debt is in that circumstance where you have, for example, a spouse who incurs significant student loan debt and then is asked and by agreement stays home to be a homemaker, whether it's a stay-at-home mom, stay-at-home dad, stay-at-home spouse, and then kind of forgoes their career, but has all this debt. And so it would be, I think, unreasonable to saddle that person with the debt, whether it may be because now they have maybe an unusable degree. But it is very fact specific. And I think community property states tend to maybe blur the lines a little bit in terms of the ability to do something like that. But, a hot topic on debt is, Christopher, home mortgages. I've often come across where, for one reason or the other, the parties put the name of the home and loan in one party's name only. And they believe by doing so at the end it's in her name only, so she should be responsible. What's Arizona going to do with that debt, regardless of how it's titled?
So that's a very hot topic, especially here in Arizona. So hotly debated that we actually had two opposing rulings that were waiting for several years in the appellate court to be decided. So, as I said, real property and other property is considered community, regardless of who is actually on the title or the mortgage. What happens oftentimes when you go to buy a house and you're married and two people, only one person's going to be on the mortgage, the title company will require one spouse to sign a disclaimer deed. That actually is what it sounds like. You're disclaiming any interest in that property. So if you don't turn around after the loan is finalized and put that other spouse back on the title, you could have some issues in your divorce. That's where those two cases came from. But typically, it's still considered community property. And even if the house is only titled in one person's name and there is the existence of a disclaimer deed, the other spouse may have what's called an equitable lien. They still have an interest financially in the value of that real property.
Yeah. And I think it, again, in Missouri, be similar. You have these deeds, marital waivers when you go and buy a property when you're married. And people think that they carry great weight when it comes to, how the court would treat it, but it really doesn't, I think. And, in terms of, you have to look at the facts of, did you start making mortgage payments with marital assets, taxes, improvements, whatever it may be. So it's a really interesting. Christine, how do they treat it in Colorado with homes and loans in one name only?
It's going to be a marital debt because, a lot of times, Scott, there could be credit reasons why only one spouse is only named on the mortgage. And again, it is a fact specific inquiry because, it comes into, we're looking at how is that debt paid off? And again, if we were using marital funds to pay off the debt, it's only fair that we're transmuting it into a joint marital debt.
So does a prenup or a postnup, obviously it could deal with debts. I'm curious because I don't know the answer to this at all within a community property state. What effect does a prenup have?
Prenups are a great tool, even in a community property state, and probably more so in a community property state because the assumption is that everything is community. So prenups can, if they're executed correctly, and the parties follow what is actually in the prenup, can be extremely helpful in a divorce and actually setting aside some of these community property laws and determining what exactly is sole and separate and what has to be shared. The problem we see with debts, it depends on whether the debt was accrued prior to or during the marriage. So any existing debts that are out there before you do, say, a prenuptial would be before you get married. Those debts you would almost certainly say these are going to remain sole and separate. They started out as sole and separate. We even can put clauses that say that any future debts that are placed only in a sole name remain sole and separate. We try to cover all bases in prenups. A postnup, though, parties, before they actually execute a postnuptial agreement, and for people that don't know what that is, that means you've already been married and you enter into an agreement dividing possibly property after the marriage. So if there are debts that you acquired as a community, even a postnup won't necessarily protect you 100% from being responsible for that, unless you get sign off from the actual creditor.
Right. All right. Don't forget to submit your questions in the Q&A. Let's get to some of those now as we get more questions that are coming in. We have about 14 minutes left. So let's go ahead and toss this to Christine. Jacob says, thanks for doing this. My wife has a lot of medical debt that has gone to collections. These procedures happened during our marriage, but she wants me to pay for this because she only works part-time and cannot support herself. It's her medical issues, and I'm on the hook because it's occurred during our marriage. What do I do? Is that correct?
Unfortunately, in Colorado, more than likely, the court would find that it has to be shared between the parties, especially if the parties are not on a level playing field financially. I don't know if the wife is working or she's not working because of her medical condition, but if she's not working because of her medical condition, I think that that's more of a reason why the court is going to apportion probably a bigger percentage of the debt to the working spouse.
Yeah. What if in this scenario, what if it were cosmetic surgery? Would that make a difference?
I think so, because that's voluntary. I mean, I think there's a difference between a medically necessary procedure versus a voluntary cosmetic procedure. So I think we've done it where, we've made arguments that, voluntary, procedures, lip fillers and other kind of Botox, so forth, that they should be the responsibility of the party who incurred that debt.
Yeah, absolutely. Christopher, same thing in Arizona. How does that dealt with?
Not necessarily. You can certainly make the argument that it doesn't benefit the community, but I have seen the argument work the other way, that things like elective surgeries, say breast augmentations, facelifts, do benefit the community. They benefit both of the parties in the marriage, and oftentimes even cosmetic or elective surgeries or procedures, medical bills are considered community debts.
Well, so again, state to state, that's another reason why to do a consult with an attorney in your area to make sure that you get the best advice, because this isn't the place for that. We're going to try to lead you and educate you and get you the right questions to ask a lawyer who practices exclusively in family law, like we do. But that brings up that question. That's the only place to get it. It's a consultation, obviously. You can do that with us at cordell.com. You can schedule on the website and get a consult right there. So also, here's a question, stay with you, Christopher. Can there be a breach of trust between husband and wife? After 38 years, you trust your wife to do what's financially right and prudent. She takes $300,000 out of a joint marital account and purchases a condo only in her name. She planned it. Any advice?
So yes, I mean, certainly, more often than not, there's a breach of trust in a marriage. That's typically what results in people filing for divorce. So, however, if a party, there's two ways you can go about it, basically. If the party took funds from a joint account to purchase a property and placed it in their sole name, you have an argument that it is a community property because community funds were used. You also might have a claim for waste, which we were discussing earlier. And again, it depends on the law of your state, but I don't practice in a fair and equitable state, but in a community property state, it would definitely be community. You'd be entitled to reimbursement for half of the down payment, that $300,000, and potentially an increase, half of the increase of value in the property since purchasing.
Yeah, I think, and I'll get Christine's response here. In Missouri, obviously, we deal with that quite often. I have a case now where they're taking all the cash liquidity and buying assets that are encumbered, or it's all, an asset. So obviously it goes on the asset side. It can be argued as misconduct. in the marriage and used to show that it's depleted cash liquidity and the ability to do it. Now they have, far better, position with assets. Here in Missouri, we could be asking for a disproportionate share of the property because of it. We could say, okay, I want 60% of the property because she's used all the liquidity to enhance herself. She now lives debt free. Well, I'm stuck with a mortgage. So obviously that's an issue. Christine, what do you think here in Colorado or Jersey?
So I think in Colorado, Scott, it would be pretty similar to what you just explained in Missouri. We would certainly ask for a disproportionate, allocation of the balance of the marital estate. But it also, the other thing that it is pivotal here is the timing of this dissipation, because in Colorado, the filing of a divorce petition imposes an automatic injunction against both parties from either dissipating or, otherwise liquidating any other marital assets. So we would have a dissipation claim for sure, and try and make the other party whole. Or you could just try and just see what other assets are available in the estate to try and compensate for the $300,000. Because realistically, the aggrieved party in Colorado would only be entitled to 150 of that. Right. So because, we're looking at 50% of what she took out, but we would try and overcompensate the client if there is another asset available. If there isn't another asset available, if she completely depleted the estate, then we would have to file a motion to compel the sale of that property.
Yep. So let me stay with you, Christine. Well, another question is, my wife and I split everything equally. She has money from a settlement that I cannot touch, and I have money from my mother's passing that she cannot touch. That's about it. We're pretty amicable, so I think it'll be pretty easy. However, my question is, on the house, we split the house, so she's entitled to half. That's no problem, but how does that work? Do I have to pay her up front half the money of the equity? Can I pay over time? Does the realtor cost and things that are wrong with the house get factored into the decision? Do I have to refinance? Obviously, he probably has a great rate. Mortgage rates are ×4 what they were a year ago. How does Colorado deal with it? And I know I'll throw in, I just finished a case very similarly. So what do you do with on a house where you have equity and you have to pay it out?
So what I've been telling our clients right out of the gate, Scott, is to contact their mortgage lender and just find out, do they qualify to refinance, and what is going to be the new mortgage payment if they have to refinance the existing mortgage plus take out extra in order to satisfy the buyout payment due the other spouse. Unfortunately, what we're encountering is most clients can't afford to do that because they locked in that 2 or 3% interest rate 25 years ago or 15 years ago, and now it's exceedingly higher. So what we typically try and do is explore whether or not there's other assets to offset the equity interest in the property. Maybe there's a retirement account that's available. Maybe there's a brokerage account that's available. So it's almost like a checkers game. We're trying to move different assets around in order to, if the client's ultimate objective is to keep the house, our goal is going to be to try and take a look at the marital estate and see what other assets are available to do an inequitable distribution of, let's just say, a brokerage account in order to ensure that the client keeps the house. So maybe the wife gets the brokerage account and the client keeps the house. But it really depends on whether or not we can do that, whether or not there are other assets available. If, unfortunately, the house is the key asset, and the client's not inclined to tap into his separate property in order to effectuate the buyout payment, then the only option is refinance or sell the house.
Yeah. And there was an interesting, the topic came up tonight. There was an article today about the increasing number of couples who are divorcing and staying in the same house, simply because, one, they can't afford to pay out the equity, because right. Two, the mortgage rates are astronomical in the 8s right now. And especially if you have good credit, are they that, low, use that word low. But three, it just makes more sense. We always talk about how you live paycheck to paycheck, and then you have to buy 2 homes with 2 independent utilities, and you expect to live that way on the exact same income that you're living paycheck to paycheck. So it's a very interesting question. In my case, it was the very same question where we had a marital house. Opposing party wanted us to sell it or pay them all the equity, which is like $150,000 right away. We asked to be paid over time, and we were willing to do it with interest, and they refused. to do it, even though the interest rate we were offering was better than what they could get in the market. So it is this game of checkers, and it's a negotiation. And ultimately, what we did was we just used other assets to pay it off just right away and be done with it. It's a very complex issue. Now, the courts here in Missouri cannot order you to refinance. Can they do that in Colorado or Arizona?
They won't necessarily order somebody to refinance if the client wants to keep the house, and if the position at trial is, I want to keep the house, the court will generally order a specified period of time within which the client has to refinance. And if they don't qualify, then the house would have to be listed for sale.
Yeah. What about Arizona?
It's similar in Arizona. Yes, the court will allow, they can't expressly order the party to refinance. They can award the residence to a party, give them a time period to remove the other party from the loan and the title. And then if they can't do that by that time period, they set a separate time period when the house has to be listed for sale.
Yeah. Yeah. Okay. And we have a couple of more questions, and then we're probably out of time. I know Olu has a question about the UK, and generally the laws are fairly different from the UK and the US. I know generally when we talk about debts in and of themselves, they're treated very, very similarly in the UK in terms of the division and equity and the facts and circumstances to look at that. So I unfortunately, we can't give you much direction from the UK perspective as it relates to that. So I can't answer Olu's questions directly, but I do know that particularly as it relates to the debts themselves, that they do take a similar approach to the United States, other than like Arizona, not a community property state. So let me go to Sam's question. This is an interesting one on debt. Sam's currently paying back an informal $25,000 loan that his parents loan in order to purchase the current home. Christopher, how would that factor in? I run into that issue quite a bit where there's some sort of family intervention where they're providing a loan and there's no recordation or documentation for the debt in and of itself, and perhaps not even a repayment schedule, and it's very loose, and sometimes they're paying it on time and sometimes they skip months. How's it handled in Arizona?
Typically, that's at the discretion of the judge, and you're going to want to bring as much documentation as you can. If you don't, ideally, you would have formal loan documents drawn up with your family members. Very few people end up doing that. But if you can show bank statements or regular payments, consistent payments from the community to establish that that debt is legitimate, then the court will consider that, and they have the discretion to assign it to both parties.
What about in Colorado?
It's pretty the same. If the parties can establish a paper trail that there have been, some period of time where loan payments were made, then the court would divide the debt, in some capacity. But if there is no paper trail, then the debt is going to be disregarded.
All right. I think we have time for one more question. Christine. My wife and I are going through a divorce. The question is I bought and owned my house prior to our marriage, whose funds I used to purchase our new home. Do I have any claim on the new house or funds despite us being both now on the mortgage? So obviously it looks like they used the funds as a down payment. Maybe it was substantial, but they still had to get a mortgage. Subsequently, is there a claim for contribution, separate property issues? What do we have there?
So if the person has the ability to establish the paper trail showing, maybe he has the closing statement, maybe he has a bank deposit, as long as there's some tracing that we can trace the funds that went from the first house into the marital home, then we can certainly make an argument that, we want to get let's just say hypothetically, it was a $25,000 deposit. So we would want to get that $25,000 credit above and beyond whatever his share of the equity is. If we don't have the paper trail, it makes it difficult for us, because then the argument could be made that those funds were transmuted into the marital asset. And then it's going to be difficult for us to argue for that claim, for that credit.
Yeah. I think it's easy if the house is brought into the marriage and there's no debt. It gets a little complex if you're making improvements or paying taxes with marital funds, obviously. I had a similar issue where they did have a small mortgage afterwards. Our claim, we were able to show the closing documents at the purchase well before the marriage. We were able to show actually an appraisal when they got a mortgage. which kind of showed the values and where those timelines were, and then the contribution on the mortgage itself. So we just used the principal pay down as the marital portion of that, which was very small. So again, it's a lot of perhaps analysis for an attorney to do, but there is a claim to be made. You shouldn't just be assuming it's 50-50 in that regard. All right. Thanks, Christine. Christine, thanks again for joining. I appreciate it. Our time is up for today, so I appreciate for coming on board and sharing your thoughts.
Thank you,
Thanks.
Scott. Thank you.
All right, stay tuned for more Men's Divorce Podcast live version, which we do every month. Not only that, we do a recorded version, our Men's Divorce Podcast, which you can find on iTunes, you can find on YouTube, the Cordell and Cordell YouTube channel as well, where we've done all these podcast topics, which I know you'll find interest in. So subscribe to that on Apple iTunes as well. So stay tuned. Next time, check our socials. You'll find more information about the next Men's Divorce Podcast live. And if you want more information, I mentioned it earlier, about a consultation, go to CordellCordell.com, or you can give us a call, 866-DADS-LAW. But you can schedule a consult right from the website. You don't have to give us a call at all. You enter your zip code, your address. It'll pick the location nearest you. You'll have some dates to pick from. You can do it either phone, Zoom, or in person, whatever is more convenient as well for you. So until next time, have a great week.